Good morning. I'm John May. Have you been confused by the government's latest corporate enforcement policy? Have all the articles you've read on Law 360 and Lexology just left you adrift? And as a result, do you have questions about what you should do if you have credible evidence of criminal activity by your employees on behalf of your company? Well, in the next few minutes, I'm going to try to remove some of that confusion and give you an idea of what you should do if faced with this situation. Now, in all of the confusion of everything that has been said about the latest corporate enforcement policy, there really is only one thing that you can do when confronted by evidence of criminal conduct by your company. And that is, one, contact your outside white-collar counsel. Two, direct them to immediately disclose the information that you have received to the Department of Justice or your local United States Attorney's Office. And three, remediate, 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 remediate. In the past, you could take your time. You could hire outside counsel to conduct an independent internal investigation and wait till the results of that investigation to determine whether or not you needed to self-disclose. But that's no longer the case. There is an adversary, an old adversary, who's just waiting to pounce on your company should you fail to go immediately to the government and self-disclose. Who is that old adversary? The whistleblower. If a whistleblower gets to the government before you do and reports the criminal activity, you are going to lose out at your one opportunity to get a declination of criminal prosecution. Essentially, there are two categories of actions that the government can take. One is considered criminal, such as a indictment, a prosecution, a non-prosecution agreement, and a deferred prosecution agreement. You know all that. But a declination is a non-criminal disposition, and they're very rare. But today, under the government's new policies, if you get to the government and disclose information, self-disclose information, before they've had an opportunity to learn this from any other source, and they find that you had a robust compliance program and that you remediated and provided complete cooperation, there is now a presumption of a declination. Now, what does this mean? In the past, when you had the luxury of simply having a outside counsel take a year or two to come up with an internal report, you could make a weighing, a balancing decision as to whether or not it is in your interest to report or not report, to self-report, or to keep it all in-house. But that option is no longer available because the incentives for whistleblowers to come forward and tell the government the information about the criminal conduct it's aware of, the benefits to them are so great that there is not a large window of opportunity for you to go to the government. So the only safe way to proceed today is to immediately make a disclosure to the government and tell the government that you have an internal investigation that has begun and that you will keep the government on notice as to the development of those internal investigations, because you no longer have the opportunity of not self-disclosing. Because if you don't self-disclose, you won't get all of the benefits that you would otherwise get. And since one of those benefits is a declination of prosecution, you almost are certainly going to look at a shareholder derivative suit, because you will have passed up the opportunity for a declination of prosecution when all that it would take, all that it would have taken, would have been for you or your lawyer to have simply notified the government that you have uncovered evidence of a possible crime at your company. Now, you'll still do everything else. You'll still do whatever internal investigation you might want to do. You'll still have a outside firm conduct its own investigation and finally make a report. But times have changed. The bottom line today of the new corporate enforcement policy is you have to self-report if you're going to protect your company from very difficult times. This has been John May. If you have any questions about this or any matter having to do with the government's enforcement of criminal laws against employees or corporations, I can be reached by telephone or text at 954-439-6500. Thank you.